I'm sure that I will have a great time, and I hope that you will have at least a good time. We don't normally think of the First World War and international law in the same mental breath, which is odd because, of course, the contemporaries did so, very much so. And what I'm going to do tonight is to try to talk about the patterns that you see in World War I when you look at it through the lens of international law, which I think might change your point of view about what the war was about and why it was so very important. Before I look at those patterns, however, we need to focus on what questions we would ask, because I think most of us would intuitively say that the question that would jump to our mind would be, who broke the law? And that's a logical question, and it is one you should ask, but it is in fact not the main question, I think, to ask, for a number of reasons, and not just because of the difficulty sometimes of finding that out, but specifically and more importantly, international law is, for the most part, not black letter law. You can't simply look it up and then hold that up as a template for state action. It is, like all law, a matter of argument and interpretation. And in addition to that fundamental problem that I think all law shares, there is another specific and, for many people, very disturbing aspect of international law, especially the international laws of armed conflict, and that is that a breach of the law can, under certain circumstances, set the stage for changing the law. It can be a way of changing law. And let me quote Anthony D'Amato, who has written eloquently on this subject. An illegal act by a state, he writes, contains the seeds of a new legality. When a state violates an existing rule of customary international law, it undoubtedly is guilty of an illegal act. But the illegal act itself becomes a disconfirmatory instance of the underlying rule. The next state will find it somewhat easier to disobey the rule until eventually a new line of conduct will replace the original rule by a new rule. But the fact is that not all state practice has that potential. One of the very most important things is that that new state direction must be accepted by the community of states who in the end are the legislators of international law. Another problem, of course, that faces us is that in wartime there is lots of breakage. And we must be careful to distinguish breakage that is due to bloody-minded individuals or ill-disciplined ones from state policy. And even under state policy, there are state policies that the states themselves will say, don't take this as a precedent, it's an exception, and state policies that they mean to be or think, in fact, already are legal or ought to be law. This difficult relationship, the nexus between international law and politics, is a very, very close one. And international law has very fundamentally to do with politics and policy. International law, after all, are the rules of conduct of the states. They rule interstate conduct. State practice that has become over time repeated and understood as obligatory is customary international law. Following international law is a prerequisite for being considered part of the community of states. The Europeans in 1914 thought of their community of states plus a few others like the United States, Japan, Siam, and Turkey as part of the civilized world, and that was the term that they then used to denote states which followed more or less the laws of the community. Whether and how a state breaks international law or follows it will tell you a very great deal about whether it considers itself part of that community, about how it defines that community, and what its larger war aims are. For example, does it seek to work within or to reestablish the community, or to transform it utterly and hence to create new rules or new laws of conduct? So the questions to ask, I think, are not just who followed the law, but how and why states break it when they do, and how serious are those breaches? Are they merely an insignificant breakage? Are they a breakage of a sort that actually is beginning to set new law? Or has it done such fundamental damage to lawness that the law can barely recover from it? Those, I think, are better questions to ask. But before I get to the patterns, there's one more little prolegomenon, and that is that in 1914, the war broke out at a point when international law was being codified, most famously at that point at the first and second Hague Peace Conferences in 1899 and 1907. And international law was at the forefront of Europeans' self-understanding and their understanding of politics. Those codifications were the culmination of 100 years of state building after the Napoleonic debacle. They were the expression of the solidification of the European state system and its system of security. It's not too much to say that international law was the language of diplomacy, and in my view it still is. And international law had reflected and encouraged a great amount of public interest, and you might recall that this is the moment of the founding of the first NGO, which is the Red Cross. You can also see this in the pacifist movement, in the socialist movement, and so on. So it was, in fact, natural that Europeans would have expected the war to come to more or less follow these laws, with which most people were, or most newspaper readers in any event, were vaguely familiar. They thought in legal categories as they watched the war unfold, and they measured war conduct against the law. And this is why the great causes célèbres of the First World War were precisely the ones that they were. The violation of Belgian neutrality, to which Professor Rozier has already alluded, the Belgian atrocities, and that was as they were known, the burning of Louvain, the sinking of the Lusitania, the use of poison gas, unrestricted submarine warfare, aerial bombardment. All of these things were major, not incidents, but they're major policy decisions and actions taken in the war that galvanized the world. World War I also, and I should of course also point out that at least two of the powers, Great Britain and the United States, enter the war conditioned and partly determined by international law and their understanding that Imperial Germany had violated that. World War I also spurred the development of international law in the directions in which it still develops today. The League of Nations was, of course, the precursor to the United Nations, which is the most preeminent institutional fount of international law today. The laws about gas warfare, unrestricted submarine warfare, air bombardment, protection of civilians, post-war trials for war criminals, all of that stuff comes out of the First World War. It's interrupted, the developments are then interrupted by the Second World War, and many people make a conceptual error then to understand the post-1945 developments strictly as a response to the Second World War. They're not. They are a response to the First World War. they were, as we know, picked up then immediately in 1946. I believe that neither the history of international law nor the history of the First World War can be written without one another. World War I can, in fact, be interpreted as a gigantic struggle over the future of international law and therefore the future of the state system. That was the Allied interpretation, and I actually think that that interpretation is largely, although not entirely correct, as you will see. So, on to the pattern. The Allies alleged that Imperial Germany was a great scofflaw, that it was a criminal state, that it had no use for law and didn't care about it. And they had some reason to arrive at that conclusion. In the first month of the war, just in the 30 days, you had the violation of Belgian neutrality, which, as Professor Rozier has pointed out, was a treaty dating back to 1839, actually an earlier one in 1831, reaffirmed by all the great powers in 1870. It was the strongest treaty in Europe and the linchpin of European security. So the violation of that treaty was really a very big deal, despite the scrap of paper. The massacre of civilians, which occurred immediately as Germany crossed the Belgian border, and these became known as the Belgian atrocities. They also included northern France, and over 6,000 civilians died on that account. The aerial bombardment of Paris began already in August 1914 without any military object in view. The purposive destruction of cultural objects, most famously the burning of the famous medieval library at Louvain, and the shelling of Reims, the Gothic cathedral at Reims, which made a little bit more sense, but nonetheless. These things were then quickly followed in February 1915 by Germany's announcement of unrestricted submarine warfare, which meant that they would sink anything that came into British waters without trying to save passengers or crew, as customary international law demanded. And then in April 1915, the first use of lethal poison gas. The point of sort of drawing your attention to how quickly these events happened is to warn you against a, I think, frequent misconception in the war, and that is that Germany's actions were somehow the result of the radicalization brought on by the war itself. They were not. They were actions and patterns of conduct actually of pretty long standing. But the Allies were quite wrong that Germany did not care about international law. The German government thought that its actions were largely justified, either because they had a different interpretation of what the law actually said, or a different interpretation of customary international law, or because of their very capacious definition of military necessity and state preservation. These differences were profound enough that they amount to a different set of legal principles to ground the state order of Europe. And they have a very long background. And in fact, Europe had been discussing these differences at the very latest since 1874. This was a conference at Brussels that was the result of the European discomfiture at the manner in which Germany had conducted the war against France. That was the third war of German unification. And so these positions were very well thought out already in 1874, again in 1899, and to a lesser extent in 1907. The German claims resulted primarily from actions that had been taken by the army that were then covered by the government, and then in these later discussions raised to a doctrinal level. Okay, so that there's a kind of abstraction from state action. And these specific disagreements occurred about codified law, that is the Hague Rules of Land Warfare, specifically about occupation, what an occupant can do, what it can take from an occupied zone, how it establishes a legal occupation in the first place. They had disagreements about who was a legitimate combatant and who was not. Relating to customary international law, the disagreement between Germany and most of the other European states concerning reprisal was so great that it couldn't be codified, so that's silent in the Hague rules, and in fact remains then under the sway of customary international law. The German disagreement about military necessity was the one that the Allies thought explained everything else. And here you must understand there are two different concepts of military necessity that exist in international law, because military necessity is an international legal term. The first and broader, more general one everybody agreed on, and that was military necessity is that thing which says that wars are inevitably going to be fought, and that a soldier who kills or who destroys property is not a murderer or a vandal, all right? He is, at this point, he, nowadays he or she, who is a legitimate soldier is then acting legitimately in this. So that's one understanding of military necessity. But there is a narrower understanding of military necessity, which is an exception to an actual rule. It is an exception that permits you to bracket that and indeed not follow the law under certain circumstances. And in 1899, the very extended discussion at The Hague showed that most European states believed that that exception was a very, very narrow one, that you could call upon only under very specific circumstances relating to very specific places in the law where you find the words as far as possible, meaning that you are held to this rule as far as possible. But where that phrase doesn't exist, you cannot claim military necessity. And in fact, in our day, military necessity has been narrowed even further to mean that you can only claim it when it is physically impossible for you to uphold it in those specific instances. The German understanding of military necessity was that it routinely overrode legal restrictions. And this is an idea which was first enunciated as a doctrine by the military men, and then made its way by the late 1880s into German legal texts, especially the canonical text by Karl Lüder in 1889. And he then titled himself, following actually an earlier article by a German cavalry general, a military realist. So this is the view of military realism. And military realism holds that the nature of war is, quote, unlimited force, unquote. And that nature was, quote, a lex lata naturae, a really existing natural law located in the nature and history of the phenomenon of war itself. This doctrine has profound implications on lawmaking, because that argument says that it is not the community of states that make a law limiting war or defining it, but it is the putative nature of war itself that produces the law. And no law that comes from outside that nature can be taken to limit the natural progression of war in whatever way. And I've called this position war positivism. And I think that the Allies didn't in some ways understand what a very profound legal position this was. Germany also had a very extreme, exceptional view of state preservation, which is what Bethmann-Hollweg declares in trying to explain to the Reichstag why Germany has violated Belgian neutrality. And this was an idea which included the notion of development in self-preservation. That is, the idea was that it wasn't enough to preserve a state within its current boundaries, but that the state had to be preserved only in its potential for development. And that might include, and in fact, once the war started, did include the disappearance of other places in service of that development. In a speech to the Reichstag in December of 1914, Bethmann Hollweg labeled the idea of a balance of power, the purpose of which was to keep everybody within their separate boundaries, as, quote, threatening and, quote, aggressive, because it hindered, quote, the free development of our energies. During the war, there was a further development in thinking about international law, which I have titled weapons positivism, and it represents a kind of a narrowing of that view of war positivism. And it basically said that it was not so much whatever was going on in a larger conduct of war, the use of force, but in fact the peculiar nature of a weapon itself which determined the laws of armed conflict relating to that weapon. And this argument came out in relation to that new weapon, the submarine. And here is Vice Admiral Reinhard Scheer explaining that, quote, the new weapon demands a new law. And you'd expect a naval man to say something like that. But you wouldn't expect, or I didn't expect, the chief German constitutional lawyer, Paul Laband, to agree, and here is he in 1915. The use of a weapon is determined by its characteristics, Beschaffenheit, and the rules that arose for battle with other weapons cannot be applied unchanged to the new weapon. And if you think about this, there are two really interesting consequences that this has for lawmaking again. The first is that it posits that there are out there in real existing war law-free zones. And they're actually created by technological development, okay? That just pushes aside the law and postulates that general principles that you can discover or that have even been enunciated as part of the laws of war cannot be extended into those law-free zones, because it's the nature of the weapon that should determine how you use them and not limits coming from outside. So that's the first. And the second is that both war and weapons positivism assume that the state that is clever enough to have developed such a weapon, or perspicacious enough to understand the nature of war, is the legislator. Okay, not the community of states. Okay. Now, no state in World War I or at any other time is univocal. There are always disagreements inside states, and there were a lot of them in World War I, a whole lot of them, including inside the German government. And those fights were not always just between the military and the civilians. In fact, Bethmann Hollweg does not come out well in a lot of this, and we could talk more about that in the question and answer period if you'd like. But in Germany, just like in all of the other nations, the fount of international legal sensitivity, shall we say, in policy making was in the Foreign Office. They are the ones in all of the countries that are in charge of keeping the government honest, or semi-honest. Sometimes that's the best you can do. And that was true also in Germany. And the German Foreign Office tried to mitigate a whole series of things. In occupation, it was the German Foreign Office that insisted that the German guidelines for occupation, which were being drawn up in August of 1914, should include mention of the Hague Rules of land warfare. Otherwise, they were going to be absent. They tried manfully to stop the really, it's not a word I use often, the really disgusting reprisals, that spiral of reprisals that were taken against prisoners of war. They tried to stop the aerial bombardment of London. And they were at the forefront of trying to compromise unrestricted submarine warfare by steadily expanding the category of ships in which you would in fact follow what are known as cruiser rules, which just means surfacing and taking the passengers and crews off. But they were prevented in every one of these cases, ultimately, from success. And part of this was due to poor leadership on the part of Bethmann Hollweg, whose position on the scrap of paper, alas, was duplicated in a number of different other places during the war. But even the Kaiser couldn't put through, and the Kaiser comes off better than John Rühl and some other historians imagine. The Kaiser was appalled by some of the consequences of actually Germany's actions and wanted to stop them, but even he couldn't prevail against the strength of the military. When the war was over, and one of the major scandals of the war was the deportation in 1916 and 1917 of over 60,000 Belgian workers for slave labor in Germany, in the munitions factories. And this was so horrified the world that Germany actually had to retract or semi-retract this policy in 1917. When the war was over, the Reichstag called Bethmann Hollweg in front of them and said, "Why on earth did you ever sign off to a policy like this?" And his answer, I think, was actually quite accurate and true. He said, "I always confronted the argument of military necessity." Military necessity, it was the military, and it's true. I think that's absolutely right. And what you're seeing in Germany is a military whose central position in the government and whose reputation as an unfailing expert in the use of force is so strong that no one dares to argue against it, and no one can really prevail against it, as I said, including even the Kaiser. Austria-Hungary, Germany's ally, produces a very interesting counterexample. Because like Germany, Austria-Hungary had, shall we say, given up on diplomacy and on the state community, and had opted for what international lawyers euphemistically refer to as self-help, namely war. And they had made that decision already in October 1913. They were going to crush Serbia at the next best opportunity. And that turning away from the mechanisms of security that were produced by the states of Europe to war seems to have encouraged Austria to pursue a conduct of the war in Serbia in 1914 that looks a lot like what Germany was doing in Belgium. You find also a widespread massacre of civilians. You find the use of illegal weapons and other sorts of things. And Germany, in fact, Austria-Hungary read the same German language law books as in Berlin, and so they shared some of the same strong ideas about military necessity. But unlike Germany, Austria was not out to change the state system of Europe. It never relinquished the idea that it was actually not just a guarantor of that system, but that system was also a guarantor of Austria-Hungary. And as a result, the Austrians were much more sensitive to world opinion and much more inclined to understand that international law might be something that would be in their interest to follow. And in fact, they took these steps to curb the military, and I should say that the Austrian military was much more likely to listen, and indeed even solicit the opinion of the Austrian Foreign Office on matters of policy, specifically asking them what the law said and what they were permitted to do. So in fact, the use of illegal ammunition was stopped. They stopped or slowed down the extraordinary expropriation of occupied territory. They sought to establish occupation regimes which directly followed the Hague Rules, for example, rather than creating fait accompli for annexation, which was what was characteristic of the German spheres of occupation. But the most extraordinary thing was they refused to engage in unrestricted submarine warfare. The German submarines operating in the Mediterranean, in May 1915, Italy declared war on Austria, but not on Germany, and that meant Germany had no legal right to sink Italian ships. But it had submarines in the Mediterranean, and those submarines then flew the Austrian flag in order to cover this. But the Austrians insisted that those submarines should always follow cruiser rules. And when Germany in January 1917 threw over the law altogether, and this is of course what brought in the United States, and without even declaring reprisal, went forward and with unrestricted submarine warfare as a state policy, Austria felt obliged as an ally to say, yes, we agree with that, but in fact, all of their captains were forbidden to act on that basis. Austria never followed unrestricted submarine warfare, even though that statement put the odium on it as though it had. There's one other thing to mention, and that is that when Austria was proven to be guilty of a major violation, it would just go silent. It wouldn't say, deny it, or say, this is the law, or this ought to be the law. That contrasts remarkably with Imperial Germany, which was rarely silent, and which made all kinds of arguments, which ranged from a kind of legalistic nitpicking, and one of the great examples of this is if you look into what they had to say about Belgium and why it wasn't really a neutral state. They made the argument of tu quoque, which is you did it too, and therefore I'm okay to do it because somehow if you have a violation, it nullifies the law. They were very strongly used the argument of reprisal, of military necessity, as we've seen, weapons positivism, and the notion that state preservation trumps international law. The Allies broke the rules too. They didn't do it as much, they did it for different reasons, and they used different arguments. And cynics would reply here, well, they didn't need to break the law as much because they were more powerful, and in fact, international law costs money and resources often to follow, or that international law actually favored them, favored their aims in the war. I find that those cynics rarely extend that argument to ask, if Germany was so weak, then why did it risk, or according to some people, actually launch World War I? And in any event, what does it say about Imperial Germany that its goals and methods could be applied only outside the parameters that were normal for other European state practice? But let me take the blockade as an example, because the blockade is the biggest example of Allied obstreperousness. And after March 1915, the British blockade was absolutely illegal. There's no question about it. One of the first differences you notice is how they make their decisions in Britain. Who makes those decisions? All of these decisions are lengthy discussions that always include the Foreign Office, the Attorney General, the Procurator General. He's the fellow who brings cases in front of the prize court. They all end up in front of the cabinet, and they are argued about all the time. Then throughout the whole war, there is an argument, there are a series of arguments that goes on inside the British government. It is not the Admiralty that runs the blockade, as it is true in Germany. It's the Foreign Office that does it. The Admiralty, in fact, does sometimes jump ahead of the Foreign Office, and the Foreign Office finds it very difficult and sometimes impossible to rein them in. And that's a very nice example of the tendency of military organizations to form their own realities, shall we say, regardless of what law might say. But the method of breakage is extremely important, the manner in which Britain does this. And it shows an extraordinary sensitivity, like Austria showed, to foreign opinion, and an extraordinary sense of Britain's own self-identification as a law-abiding nation, even when it was breaking the law. It puts the blockade in very gradually so as to accustom those who are going to suffer from it most, the neutral countries, in short, to what is going to happen. It involves all of them in lengthy negotiations throughout the war, and these negotiations are not just with the states, but they're with the traders and shippers themselves, in other words, with the private folks. They negotiate with everybody. They make things as easy and efficient for them as is possible. The blockade is, in fact, effective. It's a real blockade. The German blockade using the submarines was, in fact, not effective. And here's one of the very most important things. They always argue from the extension of customary international legal principles into a new situation. They never argue military necessity, even though if you go into the documents, you can find that they do believe in military necessity as an exception. But they never argue that publicly. What they argue instead is that what they are trying to do is to do with sometimes new means the age-old thing of blockade or seizure of contraband. They provided legal venues for those whose interests had been hurt, and this is before the prize court, and the British prize court does not follow British domestic law. It follows international law. And that means it does not follow automatically the orders in council that are the legal documents that do the blockade. That's not what it follows. So it's a genuine legal venue. And when that legal venue finds that, in fact, the Admiralty has overstepped, which it did on more than one occasion, then the victims were compensated. And if, for example, your ship were being brought into Folkestone to be looked at and it ran aground and you lost it, you were compensated full price for the ship and the cargo plus 5%. Okay, this is a way to buy everybody off. This is, in other words, breakage that is trying to go out of its way not to do fundamental damage to the actual foundations of law. That's the point here. So in conclusion, the Allies used their victory in 1918 to try to reestablish international law from the, quote, dangerous challenge to the fundamental principles of public law, unquote, that Germany had posed. That quote is from the Attorney General of Britain, Frederick E. Smith, in 1918. And the Treaty of Versailles, as you know, called for war crimes trials, for putting together an international tribunal and even more precedent-setting, actually trying heads of state for breaking international law. And the League of Nations was set up as a security organization whose purpose was to keep the peace, among other things, by, quote, the firm establishment of the understandings of international law as the actual rule of conduct among governments, and by the maintenance of justice and a scrupulous respect for all treaty obligations in the dealings of organized peoples with one another, which we know didn't work, but nonetheless, there is the attempt. And it should cause one to ask, what would have happened if Germany had won the war? What would have happened to international law? What could we expect it to have done? Could we expect it to have established a stable system of law? And I think that the answer is no. If you look at the Kaiserreich's legal principles, both as it enunciated them and as it lived them, you will notice that there are three big characteristics of them. One is an extraordinary dynamism. It is very, very situational. And the idea is that it's a system that is very sensitive to any changes that have gone on, and which will then argue that those changes somehow undermine and or replace or should replace the laws that have existed prior to that. It is, pardon the expression, and this is its second characteristic, autistic in the sense that, or you might call it monadistic. It revolves around its own self as a lawgiver as opposed to understanding a community of states as a lawgiver. And third, it makes the exception the rule. And many of you will be familiar with the doctrinal and quasi-philosophical writings on this subject by Carl Schmitt, who is, in my view, incorrectly given credit for adumbrating all of this. In fact, he picks it all up from what the German government had been doing and saying in World War I. I have been helped in thinking about sort of what law is, what is lawness, by an anthropologist of law, Leopold Pospisil, who went out into somewhere in the South Pacific, and he found himself a society which is not unlike the Society of States in 1914, which is to say, there wasn't a monarch or a single head of state or a president. There were no, in the case of this place, there were no written down laws. There are some in Europe. There was no court system. There was no police. In other words, you have none of the institutions that we typically associate with law. And yet he discovered law functioning. And he discovered it functioning if four characteristics coincided: authority, sanction, obligation, and universal application. Germany had two of these, but it lacked two others. And the two that it had in different forms than were, shall we say, normal and expected from European states. It certainly had authority, but the authority was not the authority of the community of states, but it was the authority either of war or of the weapons, a new weapon, or of the country that had produced or understood those. And one of the editor of Germany's only international legal journal, the fact that it only had one is not unusual, that international legal journals had really just sort of been invented. But this fellow's name is Joseph Kohler from 1915, and he referred to this mirage of a community of nations which dictates the norms of international law and which as a rule decides conflicts. And he said that would be, with a German victory, which he expected to happen, that would be replaced by an Areopagus led by Germany minus all of the belligerent allies on the other side, plus those neutral nations that he thought had misbehaved, namely Norway, the Netherlands, and Denmark. So you have authority, but it's a very different kind of authority than you have otherwise. Sanction, you certainly have sanctions, but it is remarkable to me that the sanctions that you see Imperial Germany using most frequently are the sanctions of war for peacetime or reprisal. In other words, the use of extreme force. Minus the whole panoply of other sanctions that you see Great Britain playing like a harp, that range from all kinds of diplomatic things to economic slights to economic carrots, and so on and so forth. The whole panoply of normal things that go into upholding international law. But the other two characteristics, military necessity and war positivism and the understanding of state preservation, destroy. And that is the notion of obligation, because it's very difficult. The number of exceptions to obligation are so great that it's hard to see how obligation could live through it, as it were. And there is no universal application, which is canceled out by military necessity. In short, I don't think that Imperial Germany could have produced, if it followed if the laws that it put into effect followed the template that it was acting on and had decided for itself, I don't think that it could have produced that. And actually, there's a really interesting document from October 1914 that the Foreign Office drew up, the German Foreign Office, which agrees with me. The Bethmann Hollweg asked them to draw up a document that would set down the legal foundation for Germany's permanent annexation of Belgium. As a real legal document. And they basically wrote back and said, we can't do this because essentially it will rest on force, and the only thing that will happen is that any kind of permanent institutions that we build up will constantly be destroyed by the efforts of the Belgians, upheld by everybody else in Europe to escape from this. It's a very, very interesting document. All right. So, looking at international law, I think, gives us a much more precise idea of the really great stakes involved in this war, and not only about how the war was conducted, but what it was actually about. Thank you. I'm happy to answer questions, and there must be some somewhere. Yes?
Some of the illegal weapons, apart from submarines, that were being used.
Yes. They were explosive bullets in the case of Austria, and they handed them out in the most bizarre way. They handed, this is right at the beginning of the war, as Austria goes into Serbia, they gave each guy 10 regular cartridges of the normal kind, and then 10 that would flatten out on contact and were therefore a form of dum-dum bullet, actually. And these were to be used against the guerrillas who did exist and who did fight in Serbia. And the way everybody knows what the Serbs are going to do is that they had done it in 1912 and 1913 in the First and Second Balkan Wars. And they produced irregular fighters called komitaji who were not uniformed and who engaged in guerrilla warfare and who were in fact very brutal and were mostly in charge. They are the people who are guilty of huge massacres, especially of Albanians, but also of Macedonians and Bulgarians in certain places where they were. And there is a Carnegie Commission report from 1913 that published all of this information, investigated it and published it, so everybody knew about it. And the Austrians then were prepared, as it were, for this, and they were doubtless over-prepared. And so they discovered komitaji where there were none, where there were just innocent civilians. But in any event, they gave out these munitions, and they had them also in the Eastern Front, and the Russians captured a depot, and then started using these cartridges, and the Austrians were about to cry foul and say, oh, but you're in violation of international law, and somebody looked at the label and said, oh my God, there are cartridges, we can't say anything about this. And that was the first time that the Foreign Office learned anything about this.
What made them illegal?
What makes them illegal is the definition of a legal round is one where the mantle is complete and entire. And so that when the bullet hits you, it does not flatten out like a bullet that you use in hunting, but will in fact go right through you instead of creating a horrible wound.
Who legislated that?
That's from the Hague. Yes, and that's actually a really interesting thing. When you go into the archives in Europe and you pull out boxes, some of them from the First World War on the subject of international law, some of them you notice are very heavy and they rattle. And when you open them up, there are dum-dum bullets inside, which and most of them that I have found in the archives were created by the soldiers themselves. They're not manufactured. Some nasty person took out his bayonet and cut a cross through the top, so that when that bullet would hit a soldier, it would flatten out like this and make a terrible wound. Everybody declared that everybody else used dum-dum bullets. In fact, it was very rare, and mostly what people were seeing were the exit wounds of very fast-traveling legal bullets, which just blew the flesh apart and were horrible wounds, and European doctors had not seen these, and so they misidentified a lot of what they saw from that. But it was the dum-dum business is very important, and as an indicator both of the sensitivity to law and also of the enormous mistrust of your foe that occurred almost instantly. Yes?
The reasoning that Germany used in Belgium that Austria used in Serbia, is that the same reasoning that the Turks used in Armenia? Is that more nationalistic?
Would you like a microphone?
Oh, sure.
Thank you.
The reasoning that Germany used in Belgium and the reasoning the Austrians used in Serbia, was that the same that the Turks used in Armenia, or was that more nationalistic in terms of that they can go in there and do what they feel is within legal means?
Of course, before the Turkish armies, especially in 1918, ended up in the Caucasus, they were within their own territory. So what they were doing was to their own nationals, right? There are two schools of thought. One is actually that the Committee of Union and Progress joined the war in 1914 in order to produce a final solution to the Armenian and Greek and Christian question altogether, to prevent intervention, humanitarian intervention by the Western powers, especially by Russia and secondarily by France and Britain. The more kind of historical view is that they got involved in the war in order to throw off at least the capitulations, but what they expected the Armenians to be disloyal. And when they failed in the battle in December and January, right on the border between Russia and the Ottoman Empire, and lost 80+% of their army, they were convinced that Armenians, and some of the Armenians that were fighting were, of course, Russians, Russian Armenians with the Russian armies. They were convinced that the Armenians were perfidious and that they had to be eliminated, and they then set about doing that. They were certainly encouraged in that by a handful of German officers in that area who wanted these people deported but not necessarily killed. It's not clear what anyone at that point thought deportation amounted to. But deportation was used as definitely a state policy to eliminate the Armenian population, and they did that. And that's a very different thing than is occurring in either Belgium or Serbia, despite the enormous loss of life in Serbia. Serbia lost percentage-wise more than any other nation in World War I, and the loss of life among male Serbs was extremely high, and so on. But it's not a question of, it's not a case of ethnic cleansing, a horrible phrase. It's not that. So it's a different issue. Yes.
I'll get up if I may, Dr. Hull. I need to stretch. Thank you for that really quite extraordinary speech that you just gave us. Most informative and most stimulating. I just want to focus in on something that you said in the introduction to your talk, to make sure I understood what you said. It sounded as if you were saying that the experience in World War was much more important in developing the later law, particularly in terms of the UN Charter, as compared to World War II. Is that correct, or did I misunderstand what you were saying?
You did not misunderstand me, but what the point is sort of a bigger one. The laws that responded to the new weapons and the new situations that existed in World War I were either already on the books or were actually, for example, the great novum after the war in terms of international law is at first not the United Nations Charter, but the 1949 revisions of the Geneva Convention. And the great thing that does is for the first time to have an entire Geneva Convention dedicated to protecting civilians. That was already drawn up in the 1930s and hadn't quite made it into a convention when the war broke out. And what I'm arguing against is the position which is the kind of the normal historiographical argument, which doesn't think that World War I was important concerning international law, and that the interwar years are a period where everybody tried to deal with the problems of the laws of armed conflict by simply outlawing war altogether, and then you didn't have to worry about the law. But in fact, if you actually look, they were worrying about the law a whole lot, and they had managed to produce a number of conventions, and they were busy, as I said, producing essentially the drafts that will then be done in 1949. So I'm not belittling the response that everyone had to the ghastliness of World War II, but I am arguing that in fact if you hadn't had World War II, you would still have been developing in that direction on the basis of what had happened in World War I, which is a lot worse than people think. The World War I was a really terrible war, and gave us with the exception of the atomic bomb, it gave us all the weapons that we used in World War II. And of course it gives us the Armenian genocide, because it's only under the cover of war and impelled by the paranoia and desperation that war does that could have occurred. So I think that World War I has been very much left out of the development of international law, making it seem much choppier and kind of more bizarre than it really is.
Let me just perhaps restate what I think you're saying. It seems to me what you're saying is not so much that the developments in World War II were rather insignificant in terms of developing international law, but rather what hasn't been really focused in on adequately is the importance of the various developments that occurred during World War I, and I assume after World War I at the peace conference.
That's
Is that
correct.
fair?
That's right.
Thank you very much.
Yeah, sure. Thank you for the clarification. Yes. Is there an international law about military necessity? Yes, and in fact, what you'll find is that both kinds of military necessity are still talked about in international law. The general one, which I mentioned, which is to say that in well, I don't want to use the word legitimate war, but when a war has gone on and a state is pursuing a war, that military necessity is the thing that makes killing not murder, okay? So everybody still has that, and there are some people who consider that to be one of the 4 core principles of international law. And I think that's a little bit not right, but and then there's the much more narrowly focused notion of military necessity, which now basically is said to be this, that in those places, and of course, the international laws of armed conflict have been very, very much more codified since, especially because of Geneva 1949, and laterally because of the additional protocols 1 and 2 in 1977. And the argument now is that you can claim military necessity as an excuse, only an excuse, not a justification or a rationale, an excuse in those particular places in those codifications where some phrase like "as far as possible" appears, and that's it. You can't do it for anything else. Pardon me? Yeah, that, and you can, when, you know, military necessity demanded that, da-da-da-da, and
squad, you're traveling on the road, you come across some enemy soldiers, and you capture them. And your orders from your lieutenant to execute those prisoners, obviously, so they won't return to battle again. Is that a military necessity?
no.
Okay.
Nope. There is no, and in World War I, there was, and in 1899, there was an argument about exactly that point. And customary international law, as I read the deliberations in 1899, was quite clear, even then, that you were in fact not under that circumstance permitted to use force, lethal force against. It doesn't matter. Actually, the following order of things is a really interesting issue. The German military code was much better in allowing soldiers, and indeed demanding of them that they use their common sense about orders that were against the law, than was true, for example, in the British military code or in the American military code. And if you look at where that comes from, it appears to come from Lasse Oppenheim, who was originally German, went to Britain and wrote the famous International Legal Handbook, first in 1905, then in 1912, and it's been revised ever since. It's like the law book. And he brought in certain German ideas, and that was actually one of them, the idea that you could hide behind the problem of superior orders. And in the deliberations concerning the Treaty of Versailles, they argued about that, about whether anyone could hide behind that, and basically decided that that was not something that was that there were very strong arguments made against that. But one of the arguments for trying Kaiser Wilhelm and Erich von Falkenhayn and Erich Ludendorff and the guys at the top was so that you wouldn't end up with a bunch of guys down at the bottom who were going to be held responsible for what they did, and you didn't hold the order givers responsible. It's one of the main arguments they use in order to extend legal liability for war crimes upward, up the ladder. So it's a very important set of issues there. Yes?
I hope I'm wrong, but I'm going to look at this as a cynic.
Mm-hmm.
And I would argue that international law is the friend of the egregious because it doesn't constrain them to do things they want to do, whereas it might constrain the defender from going down that road. Can you help me get rid of that feeling?
Tell me exactly what you mean about, did you hear him? You want to repeat that, huh?
That means I can change it. I was saying, I hope I'm wrong.
Can you hear? It's not on. You have to turn it some little doodad.
Maybe it's better that it's not on. Okay, now can you hear me?
Now can you hear me?
Now hear this.
I was taking the role of a cynic in saying that perhaps international law is the friend of the egregious aggressor because it doesn't stop them from doing what they want to do anyway, whereas it might hold back the law-abiding defender from using all the techniques that are being used against them. Help me get rid of that feeling.
This is a very common perturbation, let's say, that I think everybody has when they think about difficult, knotty problems of war and peace and so on. International law will no more hold back a state which, for whatever reasons, makes the decision that it's going to go ahead and do something, then domestic law will hold back a murderer who has made up his mind to do the same thing for whatever reasons. So from that perspective, I don't think it's particularly cynical, but it does not mean any more for international law than for domestic law that the law somehow doesn't exist in that case. Nobody would say that because Charlie Manson existed, that the laws against murder in the state of California were somehow null and void. And yet people do use that argument relating to states. And that wasn't what you said, but it is something that follows very slipstreams into the wake of the perturbation that you mentioned. And there is a problem, indeed, with, we'll take it, the possibility that a state will be held back from doing certain things, and another egregious, an egregious attacker, in your words, will not be so held back. This problem has actually become somewhat more acute since Geneva revisions of 1949 and since the additional protocols in 1977, because for the standard way that the poor defender would respond in a case like that would be to use reprisal in the old days. Reprisal is not revenge and it's not retaliation. Reprisal is an extraordinary legal situation in which an otherwise unlawful act is permitted in order to bring a miscreant back to following the law. And there are all sorts of things that you have to find out that it's really state policy and not some bloody-minded individual. Your information has to be good. You have to warn them first. Your reprisal must be proportionate. When they cease behaving badly, you must stop. And those are the basically customary international legal rules for reprisal, and that was what you could do. And reprisal is a disturbing thing because, first of all, it is the use of an otherwise unlawful means, which is under those circumstances permitted, and it hits the innocent and not the guilty for the most part, so that you reprise against some hapless POW in your hands or some alien that you have detained, enemy alien or something like this. And as a result of the horrible reprisals in World War I against prisoners of war, that was made illegal in 1929. And in 1949, you added civilians and their property. And now what has happened is that the only people against whom you now could do a legal reprisal would be fighting troops. And it's hard to see how you could do that, actually. And this has raised the problem of what, in fact, the hapless defender does in the face of really, really horrendous activity by somebody else. And what's supposed to happen in that case is that you're supposed to, get the Security Council and gang up, basically, on the egregious attacker and crush him. That's what you're supposed to do. But these are, there's no question that this is definitely a problem, but it is not a problem that gainsays the existence of international law, which is the next step. You didn't take it, but it's the next step that people who are disturbed by that and think about it often take. Sure. Yes.
Dr. Hall, I'd like to ask you about the implications of one of the German assumptions. Thank you, Anna. I'd like to ask you about the implications for one of the Germans' warfare assumptions in the modern era. You mentioned, for instance, that because a weapon exists, it can be used even if the law hasn't caught up to it. And I was curious what you think the applications of that are today, especially with the advancements in surveillance technology for which law has not quite yet caught up.
Yeah, I mean, this is, we ought to all be thinking about the use of drones and so on, and this is actually the thing we ought to all be thinking about is atomic weapons, but and that has which are considerably more powerful and non-discriminating than drones. Drones, in fact, are ultra discriminating actually as a weapon, but. There is always, I think, a temptation for a place that thinks up a new weapon, for them to use it and to use it to whatever advantage they think it gives them, even actually when it doesn't. And the German use of the submarine is a really interesting case of that, where they thought that the nature of the submarine was stealth, and that therefore having the submarine come to the surface in order to take passengers and crew off the ship that they were then going to sink was, quote, an alienation of its nature, unquote. That's in the naval documents. In fact, if you look at the statistics, the submarines in World War I were most effective when they were on the surface and they used their deck guns to sink ships, because the early torpedoes had a tendency to run low, and they ran, 60% of them ran underneath the keel. And so so in fact it would have been better. The law actually worked in your favor in that case. But these guys had it in their head that the nature of the weapon was stealth, and therefore only the untrammeled use of it against all customary international law was called for. That, I think that is a really interesting example for people to have in their heads when they think about the use of new weapons, because in fact you don't always know what's the best way to use them. And in fact the law, the extension of legal principles might ultimately serve you much better. And in fact, I think if David Petraeus or Stanley McChrystal were here and talking about drones and stuff, they might point out that at some point the US military did its weighing of civilian versus other casualties and came down to the conclusion that in fact you had to be ultra careful not to kill civilians because it undercut your actual military goal. So I think that we have to be really careful in following down the route of weapons positivism for many reasons, including military ones. That's, I guess, my point. I don't know if that answers your question.
So much of your talk on so much of your talk on World War I and international law involved the actions between state actors on both sides. And I'd be really curious to hear your opinion on what it means to international law when so much of modern conflict is, at least in part, authored by non-state actors who don't consider themselves beholden to international law at all.
The second part is actually, we need to separate it out. The first part is that international law has tried to catch up with this, and actually already in the 1870s recognized militias, volunteers, and actually the levée en masse as legitimate combatants. And none of these people were members of the armed forces. And the levée en masse, which is the idea that if an invading force is coming across the border and the population rises up in order to prevent it, if they follow the rules of the laws of war, they are legitimate combatants. So the international law had recognized for a long, long time that there would be situations in which non-state actors were in fact legitimate combatants. So that's not as unusual as people may imagine. In 1977, well, and then there's another thing, and that is if you think about sort of the categories when you're trying to figure out, what kind of law do we apply here, you're going to try to figure out the status of the conflict, and there are three possibilities. One is international war, which is war between states. One is non-international war, which is a war that is occurring, a conflict that's occurring inside a state. And then there are things that international law does not or does not yet apply to, and that is things like riots and Ferguson, Missouri, things like that, okay? And the 1949 Geneva Conventions were the first ones which applied international law, which had always been thought of as that between states, applied to non-international conflicts. And this is Common Article 3, which that is to the rules governing soldiers, wounded, sick, and civilians. And it sets down basic humanitarian standards which must be applied to them. So that international law does apply to non-international wars, and has explicitly since 1949, and I would argue actually even before that. And in 1977, in an attempt to try to deal with the proliferation of guerrilla warfare and the problem that guerrillas do not wear uniforms and are therefore hard to distinguish from civilians, and therefore the civilian casualties tend to increase in those conflicts, they relaxed the rules by which guerrilla warriors must make themselves known. And so they got rid of the uniform requirement and replaced it by carrying arms openly while you are fighting or while you are deploying for fighting, and in the hopes that they would get guerrillas, and this is the second part of your question, to obey the laws of war. But again, the fact that there are things like ISIS or ISIL or whatever that exist and that follow no law except whatever it is they lay down on any given day is not too different from the idea that a state is doing that, and international law would apply in that case, because ISIS has got a military organization. It actually is the de facto government of a place, it's got territory, and the rest of it, so that international law does apply to it, and it is obviously completely in violation of practically everything. I mean, they have really managed a baker's dozen of major grave breaches, as the phrase goes. Yes?
In a situation like ISIS, that violates international law in many, many fronts, what is the practical value, or how does that relate to the situation itself?
Okay. I think that the chief way you're not going to be able to stop them. You're not going to be able to convince them, for a while at least, of the awfulness of what they're doing. What what their awfulness has done is to completely discredit them in the eyes of those states which actually are in a position to do something about it. The only thing to do about them is to crush them, and in my view. It is that crushing should actually happen after a Security Council resolution that says that they are in danger of they're a threat to peace, which they surely are, and then you put together a coalition and you crush them. The more interesting case is something like the old PLO, and you look at what happened to them. And they started out also as a guerrilla organization. They were never anywhere near as bad as ISIS, but they were not good. And they blew up innocent civilians, and they did it as policy, and on and on and on. And there you're looking at a really interesting thing that happens when a guerrilla organization, which basically is weak enough that it uses terror, which is always against international law because it's ineffective, that uses terror to compensate for its weakness. As they matured as an organization and as they became, or part of them, or you could do it with the IRA too, as they began to move into a political situation, it was incumbent upon them actually to begin to follow rules, and they started to do that. You can look at this, another wonderful example of this is Japan in 1904-1905, and actually in 1895, but especially in 1904-05. The Japanese desperately wanted to be recognized as on a par with the rest of the states of the world. And of course, there was a tremendous amount of racism, think of the Yellow Peril, about Japan that withheld that recognition from it. And they were very careful to follow international law and did a much better job of it actually than Russia, which was kind of moving in the other direction, because they wanted that recognition. So it's a question of whether you, that's why, that was what my point about being a member of the international community or not is all about. If you aspire to be a part of the international community, law is one of the things that you are going to have to put up with one way or another. And you can entirely discredit yourself if you do not do it, which is, of course, cold comfort to those who have been killed and the rest. And I have, that's absolutely right. But it's not negligible.
But the power of, for those people that are not interested in being part of the international community, which is so often the case. You mentioned the PLO and we talked about ISIS. What good is international law if in fact the authorities or the UN is blunted by Security Council vetoes and everything else, so that international law has no practical application or very little practical application for those that have no interest in being part of the international community?
Well, it's what will ultimately happen to ISIS is one of two things. It will either, in fact, be crushed by a coalition put together either by the United States or under the auspices of the Security Council, because there is no regional organization there that can actually do it. And I did not listen to what happened in Turkey today, but since they've got everything ready to go, actually, if they wanted to use it. So that would be one thing, and that's the more likely explanation, or the more likely thing to have happen. It's going to take, unfortunately, a long time, and the destruction is horrendous of people, of culture, of lives, of hopes, of economy, and on and on. The other possibility, which I doubt, but which is not impossible, is that they actually stay where they are, and then they actually have to rule. And then you will start to see the famous Weberian principle, that they will become institutionalized, and that as soon as you start building up institutions, you actually build up law. You can't help it. And the revolutionary aspect of their movement, if that's how you want to think of this extraordinary violence that they use, will dissipate and finally disappear. And there it is. But like I said, it's very cold comfort to the people who are trying to flee now, and who are unable to, and especially for women, I may say. So but that's not unlike, the situation where a depraved person in our community does some awful, ghastly deed, and clearly the law did not deter in that case, and may not even punish, depending on whether you can find the person or not, and the vagaries of the jury system, and so on and so forth. So, I mean, that's one of the problem with law is it's ex post facto. It's more ex post facto than it is a deterrent. But I should quote a very famous quotation by Louis Henkin, which is that almost all states, almost all of the time, follow the law. Almost all, follow almost all of the laws, and that's true. That really is true. Something like ISIS is an enormous exception, but it's a very important exception.
Thank you.
One more question, he says.
I'm wondering where colonial wars fit into your story. You described 3 types of wars, one of which was an international war. The constant waging of war against colonized populations during the period you discuss. How does that fit into your story when the international community is the community of colonizers who exclude the rest of the world from the definition of a civilized state, and thereby, I think your own work even shows, absolves themselves of the rules that they abide by amongst each other, right? And I'm thinking of the frontier wars in Northwest and Northeast India. I'm thinking of Southern Africa. So I'm just wondering where colonial wars fit into this story about the development of international law around war.
Mm-hmm. It's much more complicated than you think, because in fact, people have not really done the work yet to look and see which wars were pursued within the boundaries of international law, more or less, and which ones weren't. And there were actually quite a number of them that were explicitly, for example, wars in the west of Africa, the Ashanti Wars. The British Foreign Office and military both agreed that they would follow international law there because they considered that the Ashanti government was a genuine government, and therefore it was a war between states. In other areas, the thinking, or the cover, let's say, the legal cover for what they're doing is that the colony represents some form of a domestic area, and therefore that the rebels are criminals and are not covered by the law. In other places, they use colonial, like the guys on the spot especially, will try to figure out some strange reading of what is a protectorate, because a protectorate is not really part of your country, and it's unsure what kind of laws follow there. Sometimes they attempt to use reciprocity, which is a kind of very primitive form of international law, but one which in the 19th century people thought a great deal about and imagined, I think much more than is true, that it was some kind of core principle, and I think especially the continental powers were prone to use that kind of view. And the problem there was that most of these colonial, not all of them, not for example, Menelik in Ethiopia, but most of the other ones were asymmetrical wars, and you had the use of funny weapons and odd customs and things like this, and that then confronted the Europeans with the problem that they were facing a foe that they didn't recognize and whom they didn't understand, and with whom they were now fighting for the first time. So they didn't have a record that would let them work out a certain custom between me and you. But we really, the kind of normal view currently that everybody ascribes to without having looked into it is that international law is, as someone that I'm having an argument with now just wrote to me, always already unfair, unequal, and colonial, imperialist. And that's a kind of standard black and white, and I think completely inaccurate view of the development of international law, and that we really need to look into, and believe me, it's not easy, and I've done it. I know it's not the easiest thing in the world, to look into broadly the kinds of colonial conflict that have existed. And I actually think that when you look, you find law surprisingly more often than you would imagine. What happened in 1977 was that wars of colonial liberation were automatically recategorized as international conflicts. That's Additional Protocol 1. And that was in order to make, by then, of course, decolonialization had already occurred. And the new states, the successor states to the colonies, were uninterested in titling any, for example, the breakaway of Katanga province or something, as a decolonialist struggle. And so actually I'm not aware of any war that has occurred since 1977 in which they've actually used that determination. But the short course is, it's a very complicated story, and it has not been researched yet. And we should be, I think, very leery about accepting the Carl Schmitt position, which is that international law is simply an imperialist law which acts as a fig leaf for imperialist domination, which was his point of view sitting in the Weimar Republic, understanding Germany as a colony of the Allies.